look at these rights. So I'm sure that all of you are very familiar with the term human rights. So what do we mean by this term human rights? Human rights are nothing but any right, all the rights that you are, or all of us are entitled to just because we are born as a human being. So it is not guaranteed to us by any state or any government or any organization. We are all entitled to human rights because of our birth as a human being. So it is your birth as a human being that entitled to the human rights. So it is universal, it is applicable for every people in all part of the globe, in any part of the world, and it varies from the fundamental right to live to the more complex rights such as the rights, political rights, economic rights, cultural rights, and so on. So, which I told you that there are 30 articles in the UN Declaration of Human Rights, which talks about which has recognized human rights internationally. Let us have a very quick look at what these rights are. Can I have the slides, please? Can anybody present the slides? Hello? Okay, I think you're not able to present the slides. It's fine. Okay, fine. Can we go to the next slide? The next one. I think the slides will come, so I'm not wasting the time. Let me move ahead with the presentation. The first right is the freedom from discrimination. None of us have the right to discriminate anyone else, or nobody has the right to discriminate us on the basis of caste, color, creed, religion, nationality, language, gender, political ideology, socio-economic status, educational status, or anything for that matter, or disability or illness as well. So nobody has a right to discriminate anyone on the basis of anything. So it is a human right of every human being to have a fair treatment free from discrimination. The second one is right to life. It is the right of every person to live in a safe and secure environment with 100% freedom, absolute freedom. No one can restrain us from our freedom and security. Then freedom from slavery. Neither do we have the right to enslave anyone, nor are we the slaves of anybody. Then freedom from torture. Nobody can, none of us have the right to torture anyone physically or psychologically. And um, we are also not supposed to torture anyone physically and psychologically. Since most of the students who are listening to me, since most of the people who are listening to me right now are students, I just want to remind you, why do you think ragging is not allowed or banned in the colleges? It is purely because it is a violation of human rights. So if you ever indulge in these kind of activities, always remember that you are indulging in an activity that is a sheer violation of human rights. Can we go to the next slide, please? Yeah, okay. Right to recognition before law. All of us as human beings have a right to be legally protected by our nation, and that is why we have different legislations in our country. You must Father Bobby was talking in his presidential address about the farmers fight. Now that there is a bill in consideration for the farmers, in favor of the farmers, so there are different laws for protecting the women, children, the farmers, and the mentally ill and the people with disability and so on. So why do you think we have these kind of laws? It is because all of us have a right to be legally protected in our nation. That is why we have legislations in the country. So it is a human right to be legally protected. And free and equal. We all are born as free individuals. As I told you earlier, we are not born as slaves. We are all born free and we are equal. We are neither superior nor inferior to anybody. We are all free and equal. Now, the right to be equal before law, or right to equality before law. If we are coming in terms of conflict with law, when you are in conflict with law and when you are undergoing a litigation process, everyone in this nation or anywhere should be treated equally before the law. There is no difference between a celebrity or a industrialist or a common man or a politician or anybody. Everyone shall be treated equally before the law. Next slide. Access to justice. It is our right to access justice if we are denied of justice. That is why we have a judicial system in the country. Not only in our country, every nation have their own judicial system, because it is the right to be legally protected, and if the law is violated or the right is violated, we have the right to approach the judiciary or the court system in the nation to fight for our right. And right to a fair trial. Even if somebody is has committed a crime or committed a mistake, and even if it is so obvious that a person has committed a crime, he cannot be sentenced immediately. It is the right of every human being to get a fair trial. Every person who is accused or who is a convict shall be given a fair trial. Now, presumption of innocence. You all know this point, that even if a person is accused of committing a crime, you should treat this person as innocent until and unless the court declared him or her as guilty of having committed a crime. So you cannot consider somebody as a criminal when a case is charged against the person. So it is the discretion, or it is the final decision should come from the court. A court has a final authority to say whether a person is a criminal or not. So until the court declares a person as guilty of having committed a crime, you are not supposed to consider him as a criminal. We are supposed to consider them as innocent. So discriminating someone on the saying that he or she is a criminal is actually a violation of human rights. Freedom of movement. Everybody has the right to move freely in their country and even to other countries, definitely with proper documents. Right to asylum. This is a human right of every human being. If a person or if a group of people are persecuted in their own land by another group of people, they have the right to seek asylum, or the refugees have the right to seek asylum in another nation. So, or they also have the right to be relocated, or if they're displaced from their own nation, they have a right to be relocated into their nation. So this is a human right. But here I want to warn you that, or I want you to understand that this is not an absolute right. If you have committed a crime in your country and if you want to escape the litigation process, you cannot seek asylum in another country. That does not come within the purview of the International Declaration of Human Rights. This is a condition where a person has the right to seek asylum when she or a group of people are persecuted in their own country. Then right to nationality. Right to nationality is the right of every human being. No one shall be deprived or denied of their nationality. And it is the right of the person to change the nationality as well. Right to marriage and to found a family. This is a self-explanatory point. Then, can we go to the next slide? Freedom from arbitrary detention. Arbitrary arrest and arbitrary detention is something where a person is arrested or detained purely on the basis of personal whims and fancies or personal grudges. This is not allowed. This is a violation of human rights. If a person is arrested, then there should be a clear charge sheet against this person, and the arrest shall be recorded, and the court shall be informed, and the person shall be produced before the court, and he shall be given a chance to be heard, which we already discussed as trial, and only then the legal procedures or the sentences shall be initiated. So nobody shall be arrested or detained in any country or anywhere because out of the personal grudges or as per the whims and fancies of few people or people in power. Right to own property. It is a right of everyone. And right of religion or belief. You have all right to believe in any religion you want. You have the right to change your religion, or you have the right to start a new religion as well. Freedom of expression. It is the right of every human being to express their thoughts in words or in any creative manner, maybe in writing or in speech or in any other creative way. It is the right of the people to express their view. Then freedom of assembly. It is a human right that we are all entitled to organize a meeting or to participate in any other meeting. But at the same time, you don't have the right to force anybody to be a part of the meeting or the assembly. Right to partake in the public affairs. You have all right, provided you are 18 years of age, you have all right to partake in the public affairs. You can cast your vote, you can contest in the election, you can give your opinion, and so on. Right to social security. As students of social work, you might be knowing what the concept of social security is. It is a financial assistance given by the government for the people on on certain situations, such as unemployment benefits, sickness benefits, and so on. So it is a right of the people and a duty of the government to provide social security for people in need. And right to work. Everybody has a right to work. If you have attained the right age for working, if you're not a child, if you are an adult, you have all right to work, and of course all right to get a payment for your work. Next slide. When we say right to work, it is also accompanied with the right to leisure and rest. No one can force anybody to work without continuously round the clock without any leisure time or rest period. Everyone is entitled to weekends and holidays with pay and so on. So these are all the rights of the employees. Right to adequate standard of living in terms of proper housing, proper food, nutritious food, proper clothing, education, medical facilities. These are all the rights of a person, which is very essential in providing at least minimum standard of living. Right to education is a right of everyone. No one has a right to prevent somebody from seeking knowledge or getting professionally trained. Right to take part in cultural, artistic, and scientific life. It's self explanatory. Scientific life means research. If you have a research temper, scientific mind, you can do these kinds of research. That is also your right. Right to a free and fair world. Not only in your nation, in every part of the world, you have the right to be treated equally or treated fairly. Not equally, but treated fairly. And duty to your community. You must always remember that rights are always accompanied with duties and responsibilities. So, whatever the society is expecting from you, it is your duty to deliver those responsibilities and duties to the community. And rights are inalienable. This also Father Bobby was mentioning during his presidential address, that your rights are inalienable, which means nobody has the right to take away your rights from you. No one can snatch away your rights. Your rights are your rights. Nobody can prevent it, stop it, or snatch it, or take these rights away from you. So these are the rights of human beings, uh, recorded through the 30 articles of United Nations Declaration of Human Rights. Now, why I told you this is because this is the wider canvas, this is the umbrella, and all the other laws or legislations in our country that we go through, or the constitutional provisions that we go through, it will have some resemblance of this, because the member nations of the United Nations have incorporated these rights in their legislations or in their constitutions. Therefore, you will find and accordingly, different laws or new legislations are introduced and enacted in every nation. So this is the umbrella. You will find, or this is the wider canvas. You will find aspects of these in the while we discuss the rights of the persons with mental illness as well. Now, having said that, can we go to the next slide? Having said that, now let us move on to our topic for the day, the mental health in India, historical overview of legislation. So you know that India was a British colony, and the laws of this type were introduced or enacted by the Britishers in India. And some of the laws introduced by them we are still following, or we have followed it for a very long time. So the judicial system and the legal system of India is still influenced by the British system. So let us first consider, when we consider the historical overview, let us consider the laws in the British India passed by the British government in pre-independent India for the mentally ill persons. Those are the Lunacy Act, Supreme Court and District Court in 1858, the Indian Lunatic Asylum Act 1877, and the Indian Lunacy Act 1912. All these four acts now stands repealed. It is no longer in use and it is no longer valid. But at the same time, you should know that such acts existed, and these were the first acts or legislations that were enacted in the pre-independent India. Now, let us consider the laws enacted in independent India. It was the first act was the Mental Health Act of 1987, and currently we are following the Mental Health Care Act of 2017. Now, I just want all of you here to have a look at the 2 years, significant years here. The last act in the British India, the Indian Lunacy Act, was passed in 1912. And the first act in independent India by the Free India was passed in mental health, passed in 1987. See the gap. See, from 1912 to 1987, India became independent several years before that, 1987. So even after independence, it took several years for the Indian Parliament to be sensitive towards the needs of the mentally ill, and for the need to think about changing or making or enacting a more progressive act for the mentally ill persons. And from 87 onwards, though it was a bill in 87, it was implemented only in 1990s. And right now we have the Mental Health Care Act of 2017. Now I'm going to talk to you about the rights of the mentally ill persons as per the Mental Health Care Act of 2017, because this act came into existence in June 2017, and then onwards the earlier act, the 1987 Act, stands repealed, means no longer in use. Now, next slide, please. Now, when we talk about the rights, can you just click once again? Yeah, one more. Fine, thank you. Now, when we talk about the rights of mentally ill persons in India, we must have in mind three main acts. The main act is definitely the Mental Health Care Act of 2017, but you should also have some information on the Rights of Persons with Disabilities Act of 2016 and the National Trust Act of 1919. So, all the rights of mentally ill persons in India are protected through the provisions of these three acts. So, let us consider the first right. Next slide, please. Rights as per the Mental Health Care Act of 2017. Next slide, please. Next one. Yes, it is a right of every Indian, every Indian to access mental health center. It is a right of every one of us to have access to mental health services. So it is a duty of the government to provide quality mental health services to all its citizens at affordable cost, and every mental health services shall be made geographically accessible, which means you should not have to travel for 2, 3, 4, 5 hours in order to reach a mental hospital or receive a treatment. It should be geographically accessible. And if in your locality, if the mental health service is not accessible in the government sector, as per this act, a patient has a right to approach the private hospital, and it is the responsibility of the government to bear that cost from the of the private hospital. Now integrate, and it is also the responsibility of the appropriate government to integrate mental health services with general health care services at the primary, secondary, and the tertiary level. This can go a long way in reducing the stigma. Right now we have mental hospital specialty centers for mental health care, but if the mental health services are decentralized to the primary health centers, community health centers, to the district hospitals, and so on, visiting, going to the hospital will be like just like going to the hospital for taking treatment for fever or anything else. There will not be much of stigma. Not only that, it will become more accessible for the people. Then and as this act says that it is the responsibility of the government to provide adequate IPs inpatient, OPs outpatient services for the people in all locality, and provide supported accommodation, halfway home is a concept which the people who are admitted in the mental hospitals for a long term, if they are one fine morning discharged from the hospital to the family, they may not be able to perform very well. They may not be able to perform or do their duties and responsibilities uh, just before how they it was just before the disease. So they require a lot of training, because of the illness and because of the long term hospitalization, people might be having a lot of cognitive deficits, and they might have lost a lot of social skills. So these people need to be trained in these cognitive and other skills, and then if they are discharged to the home, and they'll be able to better deal with the people and deal with the situations. So the halfway homes are an intermediary center where the patient is discharged from the hospital and go to the halfway home, where he will be getting a lot of training in developing his skills, and then he will be sent to the home. So this is the concept of halfway home. So the this act says that it is a duty and responsibility of the government to establish as many halfway homes as possible, so that the patients will be trained in their required skills. Because in hospitals, the focus is mostly on treatment. There isn't much time, or there isn't much focus on developing their skills and equipping them to live in the community. So that part is missing. So in order to equip them in that way, halfway homes are essential. Then supported accommodation, in case if a person is homeless, or if the family is not in a position to take care of the patient, then this person shall be given a supported accommodation in the community, or home based rehabilitation centers or community based rehabilitation centers, not the institutional based rehabilitation. In institutional rehabilitation, it will be just like a hospital. The person will be restricted within the four walls, or the compound wall of the institution. He will be having a restricted life. He will not be allowed to go out and live with the community. So instead of that, the institutional rehabilitation concept shall be replaced with community based rehabilitation services. So these are the responsibilities of the government to protect the right of the mentally ill as per the Mental Health Care Act of 2017. And long term hospitalization shall be done only if necessary. Now we see a trend that once a person is admitted in mental hospital, the family members usually just go away. They never come back to visit the person or take the person back home. So there is a trend to abandon the patients in the mental hospital. This is not right. This is a sheer violation of the right of the mentally ill. A mentally ill person shall be hospitalized only if it is absolutely necessary. The moment he is fit for discharge, the moment he becomes asymptomatic, the moment that psychiatrists feel that the person is fit for discharge, he shall be discharged from the hospital. If you force him to stay in the hospital despite being fit for discharge, it is a sheer violation of his right. Then essential essential drug list shall be made available free of cost in community health centers as well as public health centers, because there can be a lot of psychiatric emergency situation, or sometimes for a patient to the usually medicines are given for a period of 1 month. So they cannot stop the medicine. They'll have to be on medication for a very long time. So if these medicines are not made available in the PHCs or CHCs in their locality, then they will have to travel a long way to the mental hospitals and again meet the doctor and buy the medicines. This will be difficult for many people, and so what happens is they stop medication. They won't come for the follow up, and as a result, relapse occurs. Relapse, as you know, is the reoccurrence of the disease. So, in order to prevent this, essential drug list shall be made available free of cost in the CHCs and the PHCs, so that along with the prescription of the psychiatrist, this can be given to them. Then Ayurveda, Siddha, Unani, homeopathy, and naturopathy medicines approved by the government shall also be made available free of cost, because this act has a new feature called Advanced Directive, about which I will be explaining in the later part. So, as per the Advanced Directive, any one of us can write now that tomorrow, if we are suffering from mental illness, what kind of treatment you want to have, whether you want an allopathy treatment, whether you want to go to a government hospital, or whether you want a homeopathy or naturopathy treatment. You can write it in a document and you can register it. So this is what is called Advanced Directive. So later on tomorrow, if you are having mental illness, everybody, the treating psychiatrist is expected to look into your Advanced Directive, and if you don't prefer an allopathy treatment, you're not supposed to be treated with that. So, and if you prefer a naturopathy treatment, then it is your right to receive naturopathy or homeopathy treatment for mental illness. So that is a new feature of this act. So this act is recognizing these branches also in treating mental illness, and such medicines shall also be made available free of cost. Can we go to the next slide? Right to the second right is the right to community living. It is the right of a mentally ill person, just like any one of us, to live with the family and society. As I told you, family cannot say turn their faces back to the person. They cannot say that, we are not allowing you inside our house, or the society cannot discriminate somebody on the basis of mental illness. um, no, no one shall be forced to stay in the mental health establishment beyond the absolutely required period. And in family, if the family is non-cooperating, then legal aid to facilitate living with the family shall be made. So it happens. Sometimes the family members admit the patient in the hospital and they never come back. So in such cases, even if we try to call them and ask them to come back to the hospital, they never turn up. In such cases, it is the right of the patient to get legal aid. So what we do is there is an organization, or there is a legal setup called the District Legal Services Authority. There is a National Legal Services Authority. There is a State Legal Services Authority, and there is a District Legal Services Authority. The District Legal Services Authority is a court which has a sub judge and advocates and other office staff. So we um, uh, we bring to the notice of the District Legal Services Authority that a patient is abandoned by his family member. So the DLSA, the District Legal Services Authority, in short, is called as DLSA. So the DLSA will make sure that the family is taken to the court and the patient is finally sent back to the family. And if a person is homeless, if a person admitted in the hospital is brought by the police, or if he was found wandering, or if he is homeless person, then it is the responsibility of the government to provide less restrictive community-based establishments, which means I was telling you earlier about the community-based rehabilitation centers. We don't have enough of community-based rehabilitation centers. We do have institutional rehabilitation centers, but this is actually again restricting their freedom. So there must be more of community-based establishments, rehabilitation centers, so that they can have a less restrictive environment. So this is what the document says. Um, Now let us have a look at the reality. The earlier right was saying that it is a right of the mentally ill person to have access geographically to the mental health services. Right now in Kerala, we have only three government level specialty centers for mental health. Those are the government mental health center at Trivandrum, Trichur, and Calicut. Then in few district hospitals, there is a psychiatry department, but there is no inpatient facility or limited inpatient facilities. And also in some of the medical colleges, they have psychiatric department, where again inpatient facility is limited. So imagine the situation. The act says that it is a right of a person to access mental health care services geographically, or geographically. But in reality, we have very limited inpatient facilities for mental health services in Kerala. So a person from Kasargod or Wayanad or Palakkad has to either travel to Calicut or to Trichur to provide, to access free government mental health services. Otherwise, they can go to the private hospital. But until this act came, the private hospitals were costly. Even now, it is costly. But this act says that if somebody has to take treatment from a private hospital, the cost is to be borne by the government. So that is the reality. We still do not have enough. There is no mental hospital established after independence. All these mental hospitals that I told you right now were established by the British government. No mental hospital have been established in Kerala after independence. And the bed strength of these hospitals have also not increased according to the requirement. So in reality, we can see that even though this is the right of a person, this right is not enjoyed by everyone equally. And at the same time, right to community living, as I said, the reality is that most of the people, most of the family members, they just get the person somehow admitted in the hospital, and they abandon them, and they don't want to come back, or they don't want to take the patient back home. Again, sometimes even the people in power, like the local representatives, local self-government representatives, they make calls and say that this person shall be admitted, this person shall not be discharged, and so on. So they are everyone, the society, the family, everyone are supposed to protect the welfare of the people, but we see that they just turn their faces against the mentally ill. So that is a reality. Now, can we go to the next slide? Right to protection from cruel, inhuman, and degrading treatment in the hospital. If a person is admitted in the hospital, within the hospital, he is entitled to, he or she is entitled to certain rights. Those are a safe and hygiene environment. Everyone shall be, just because they are mentally ill and just because they are not aware of their rights, or just because they are not in a position to raise their voice for their rights, you cannot treat them badly, or you cannot ill treat them. They should be given a safe and hygienic environment. And adequate sanitary conditions shall be provided in all hospitals. And there must be facilities for leisure, recreation, education, and religious practices. If somebody wants to pray, or if somebody wants to read a really sacred text, facilities shall be made for all those things. And right to privacy. The privacy of a patient in the mental hospital shall always be protected, shall not be violated. You cannot disclose information about the person, or you cannot make them object of visit. You cannot let the visitors come and meet them. Visitors means anyone from outside, or anyone from the neighborhood, or anyone from the community cannot come and meet these people, or cannot get information about them. So you can give the information about them only if it is only to the right persons and in the right amount. And right to proper clothing. It is a right of a mentally ill person to receive to be provided with proper clothing within the hospital. And no one shall be forced to work in the hospital. And if at all somebody is working, then he shall be paid appropriately for the work that he is doing. Next slide, please. Provision for preparing a living in the community, which means while during the stay in hospital, especially if they are having a long stay in the hospital, during this period, after the treatment, immediately the focus is definitely on treatment, on controlling the symptoms. So when a person is highly symptomatic, you cannot train them. So the first focus is definitely treatment and controlling or managing the symptoms. Once the symptoms are controlled and once the person become asymptomatic, then there must be provisions to train him in some vocation, so that even after his discharge, he will be trained in a vocation so that he can have a living of his own. Or at the same time, there must be provision for training him or her in required social skills or the lost social skills, and to manage with the cognitive deficits, at least to whatever has been whatever cognitive deficit that has happened cannot be regained, but whatever is left over, that can be maintained. Then wholesome food, sanitation, space, and access to articles of personal hygiene such as toothbrush and soap and all those things, and women's personal hygiene during menstruation. These are all the right of the people. So if somebody is asking for for paste or brush or sanitary pads, then that shall be provided for the patient. No compulsory tonsuring. Tonsuring means shaving the head off. It was a practice initially in long back in the olden days. Tonsuring or shaving the hair or the head was a common practice, because they are not very conscious of their personal hygiene. So if they don't take bath properly, then there can be hygienic issues. That is why, so it is easy to uh, maintain hygiene. For that reason, it was a practice long back. But now it is not allowed. It is against the law. No one shall be forced, or no compulsory tonsuring shall be done. Wear personal clothes if wished. If a person is admitted in a mental hospital and if he or she wants to bring his own clothes from home and wear her own clothes, then that shall be allowed. And nobody shall be forced to have uniform in the hospitals. Protection from physical, verbal, emotional, and sexual abuse. Every patient shall be protected from physical, verbal, emotional, and sexual abuse from the inmates as well as the staff. Next slide. Right to equality and non discrimination. A person shall not be discriminated in the society by the public or the hospitals based on their disability. The person with mental illness will definitely be having some kind of disability. So, based on this, no one can discriminate them in the society. Quality emergency facility. As I told you earlier, there can be psychiatric emergencies as well. See, for example, if a person is having suicidal ideation or threatening suicide, or if somebody is very violent and is likely to cause harm for the others, then these are all, or if somebody is having a catatonic stupor, these are all psychiatric emergency situations. So, just like a medical emergency, there must be facilities in the local level hospitals to deal with the psychiatric emergencies as well. And it should be, as per the act, quality emergency facility. You cannot just, if a violent person is coming to a PHC or a CHC, you cannot just tie him with whatever is available onto the window pane. That is not possible. To the window, that's not possible. You should have proper bed in the hospital with restraining facilities. So quality emergency services shall be available not only in the mental hospitals but also in all other hospitals to deal with such emergency situations. Right to ambulance. If somebody is calling ambulance to transport a mentally sick patient in times of psychiatric emergency, ambulance cannot deny their services. Just like any other medical emergency, during psychiatric emergencies also, ambulance services are required, and they have no right to deny such services to the psychiatric patients. A child under the age of 3 shall not be separated from mother taking treatment unless there is a threat to a child. Sometimes this happens that a mother is a psychiatric patient, and she has a child under the age of 3. So in that case, you when you are admitting the patient, the mother, you should admit the child along with the mother. You're not actually admitting the child, but you are allowing the child to stay with the mother. But there is a clause that unless there is a threat to this child. Sometimes the mother may be violent, or mother may be having some delusion, and under the delusion the mother may harm the child or may try to kill the child. In that case, the mother is a threat to the child. In such case, you can separate the child from the mother. But otherwise, on account of the mental illness of the mother, you cannot separate a child under the age of 3 years, even during admission to a psychiatric hospital, from her or his mother. And if at all if the doctor feel, if the psychiatrist feel that if the child stays with the mother, it is a threat to the child, then you can separate the child. You can get the child admitted to the fondling home through the child welfare committee. Uh, but if even if you have separated, then this decision shall be reviewed in every 15 days, because once the mother starts the treatment, her symptoms might improve. Her condition might improve, her symptoms shall be controlled, and she might be, there are chances that she might become normal in such a situation, but still she may require treatment for some more time. In such a situation, when the threat is over, then the child shall be brought back to the mother in the hospital. And even during the time of separation, the mother, if she wishes to see the child or want to talk to the child, provision shall be made for the mother to meet the child and talk to the child. So even if the child is transferred or shifted to another organization, uh, the hospital staff shall meet. It actually is the duty of a psychiatric social worker to make arrangements to bring the child to the hospital so that the mother and child can meet for some time. Can we go to the next slide? Right to information. It is the right of a patient, of a mentally ill patient who is admitted to the hospital, to know that why he is admitted and under which provision of what act he is admitted to the hospital. So if you are admitting a patient, you have to explain to the patient that you are going to be admitted in the hospital as per the section 86 or 87 or 88 of the Mental Health Care Act. You need not mention the section as such, but you should explain things to the patient in such a way that he understands why he is admitted. This may not be applicable in every cases. See, for example, if the patient is completely not in touch with the reality and is not ready to listen to you, in such a situation, you may not be able to explain the situation to the these things to the patient. But the patient will be having a relative or a nominated representative, as this act calls them. So you can explain the condition to the, or the situation, to the nominated representative, and later after treatment, when the patient improves, then it shall be explained to the patient as well. And right to make application to the concerned board for review of admission. See here, the board is the board I said here is what is called the Mental Health Review Board, MHRB, Mental Health Review Board. This is a new feature of this act, Mental Health Care Act of 1980, 2017. According to this act, every government shall appoint a mental health care review board, and this board is the apex body. And every psychiatric hospital, both in the government and private sector, along with the psychiatric rehabilitation centers, all of those comes under this board. And this board has the right to control and supervise and inspect and make sure any of these organizations and make sure that things are working as per the law there. So if a patient is admitted into the hospital, and if the patient feels that he and when we admit this patient, it shall be informed to the mental health care review board, and the patient also can write to the review board, and if he has got any complaints about the admission. And you should also explain the about the treatment plan and side effects to the patients. Again, if the patient is in a condition that he can understand what is being said, if he's not completely lost in touch with the reality, if he's in still in touch with the reality, the patient shall be explained what are the treatment plans and what could be the possible side effects of the treatment. There was a case in a hospital that a patient once complained, has actually lodged a complaint in court against the doctor, saying that he is having hair fall, which is a side effect of the psychiatric medication. So it is the right of the patient to, go to the court and complain against the doctors for the side effects. So it is the duty of the treating doctor to explain to the patient that these are the treatments, these are the medicines, and these are the possible side effects of these medicines, and receive information in his or her language. When you explain it, you should explain it into the patient in his or her own language. They must understand what is being told. So if you don't know the patient's language, then it is your duty to find out a translator who can translate whatever is being said to the patient, and the patient or his nominated representative understands that. Can we go to the next slide? Right to confidentiality. It is the right, as social work students, you know what is confidentiality. It is the right of every mentally ill person to keep information about him or her as a confidential information. You have no right to publish the details about the patient anywhere, or you have no right to disclose the details of the patient to anyone. So there are few exceptions. You can disclose information about the patient to the nominated representative. Nominated representative is, as I told you, is a feature of this act. If a person is admitted, he should have a nominated, either he can come on his own, or he should have a nominated representative who can be his family member, or who can be a nominated representative appointed by the court. So the nominated representative, you can disclose information about the patient to the nominated representative, or other mental health professionals. Psychiatrists can disclose the details to the psychologists or psychiatric social workers or other doctors from other medical branches if required. Protect other person from harm. Suppose if the patient is dangerous, then you may have to, and the person may be having a delusion about a neighbor, or about someone in the family, and he might be having some plans of killing this person or doing some harm to the person. In such case, for his safety or for the safety of the other person, you can disclose the information to that person, and you can disclose the information to the court. Court has the right to ask for the mental status report of the patient, and you can disclose these details to the court. And in interest of the public safety and security, when can you actually disclose the details to the public? If a person is threat to the public interest or safety. So see, for example, a person is a serial killer, and he is a psychiatric patient, and there is a possibility that he can be seriously dangerous to the society or the public. In that case, you can disclose the information to the public. No photograph or information of the patient shall be released to the media without the consent of the person. So that means with the consent you can disclose. But here again there is a problem. The person should be fit to give consent. Mentally ill person shall be fit. Out of their mental illness, they might say anything. So that cannot be taken into account. The psychiatrist should make sure that the person is fit to give consent. He is mentally fit to give the consent. In such cases, if the person is giving consent, if there is a serious requirement, if it is absolutely necessary, then the photograph of the patient can be released. Otherwise, it is not allowed. Next, right to access medical records. Patient has all right to access his medical records. If the patient says that I want to see my case sheet, I want to see what you have written, he has a right for that, and you should show the medical information to the person in normal condition. Information shall be withheld. So when can you withhold the information? You can withhold the information from the person only if it can cause serious damage to him, or if there is a likelihood of harming others. If this person comes to know a particular information about his disease, and if it is likely to harm him in any way, if it is likely to create more trauma for him, or because of that he might inflict torture upon others. In such cases, if the psychiatrist feel, he can withhold some of the information. But when you withhold an information, when the information is withheld, the patient shall be informed that he has a right to approach the mental health review board. I told you that there is a mental health review board, which is an apex body, which is supposed to be controlling and supervising all the mental health establishment, hospitals, as well as rehabilitation centers in the country, in the state also. So if you are saying that, if you're telling a patient that I cannot disclose all information to you, at the same time, you should tell the patient that, but you can approach the mental health review board for more information. And if the board feels that the information shall be given to the patient, it can be given. So I think that point is clear to you. See, normally we can give access, the patient has the right to access his medical records, and we can give information about his medical records to the patient. But in certain situation, if that sharing that information is likely to harm him in any way, then we can withhold that information. But when we are not disclosing that information, we should also tell the patient that I am not going to tell you this information, but you have a right to approach the mental health review board and get this information from them, from me, through them. Okay, so that is what this last point is all about. Can we go to the next slide? Right to personal contact and communication. During the stay in hospital, it is the right of a mentally ill patient to refuse or receive, refuse or receive visitors and calls, and also receive or send email. So it is a right. If they say that I want to make a call, there must be provisions in the hospital to make the call. Medical officer shall restrict communication if person with mental illness does not want to. So if somebody from the home or from the neighborhood is making a call or sending an email or is coming to visit the patient, maybe own relative, and if the patient does not want to meet this person, then the medical officer can restrict this communication. Uh, but there are exceptions. Judges of a competent court, members of the Mental Health Review Board, nominated representative of the patient, MLA, MP, legal representative of the patient, means the patient's lawyer, medical practitioner in charge of the person's treatment, or any other person authorized by the appropriate government can visit and meet the patient even if the patient resists to or does not want to meet him. Uh, yeah. See, for example, if the doctor is coming to visit the patient, and if the patient is saying, no, I don't want to visit the doctor, I don't want to see the doctor, in such cases, it shall not. No, this right is not actually, cannot be considered in its absolute sense. So these are some exceptions. These people have exceptions to meet the patient, irrespective of his or despite his resistance. Next slide, please. The last two rights, as per the Mental Health Care Act of 2017, as the right to legal aid. Everyone has the right to legal aid. Sometimes we see that the patient may be having a lot of property, and the family members may be enjoying this property, and the patient will be admitted in the hospital or abandoned by them in the hospital. They may never come to the hospital to visit him, or they will not even be ready to take the patient back home. In such cases, the patient has the right to get legal aid. So as I said, how do the hospital provide the legal aid? Because hospital does not have a legal officer. So we approach the district legal services authority, and we bring to their notice that the patient is having a legal need, and the DLSA on behalf of the patient will be filing the case in the court and make sure that the legal aid is free of cost. Aid is made possible for the patient. And the last one is right to make complaints about deficiencies in provisions of services. If a patient feels that he is not happy with the services in the mental health hospital or wherever he is taking treatment, he has the right to complain about these deficiencies, first to the head of the institution, and if not, and at the second level to the mental health review board. So these are the rights of the mentally ill persons as per the Mental Health Care Act of 2017. Now, can we go to the next slide? Now, rights relating to admission and discharge. See, as I told you, as per this act, any person has a right to have an advance directive, which means advance directive means anybody when they are of sound mind, in the expectation that tomorrow there is a chance that they might be suffering from mental illness. In such cases, any one of us can make an advance directive, a legal document. It's just like writing the will. You can write an advance directive saying that tomorrow, if I am suffering with mental illness, I want treatment from this particular hospital or this kind of medicine, or not the name of the medicine. I'm talking about the branches of medicine like allopathy or Ayurveda or whatever. And you can register it, and this shall be uploaded by the Mental Health Review Board in the website. So, if a patient is coming to the hospital for the first time for treatment, it is the responsibility of the psychiatrist to find out whether this person has any advance directive or not. If the person is having an advance directive, it is his responsibility to go through the advance directive and find out what kind of treatment this patient is actually preferring. And if he does not prefer an allopathy treatment, or he prefers another kind of treatment, then he shall be uh, sent for a treatment according to his choice. But there is an exception. If the situation is such that it is an absolute emergency where the patient requires immediate treatment irrespective of his advance directive, in such cases, otherwise he can be harmful for himself or for the family or for the society. In that case, the doctor can treat the patient irrespective of what is being written in the advance directive, but inform the mental health review board within 24 hours of admission or treatment. Now, as per this act, a patient has independent admission. A patient above the age of 18 years has a right to take admission independently. A person can go to the hospital and meet the doctor or the superintendent and can give in writing saying that, see, I'm having problem, I need admission. This is what is called as independent admission. But whether to admit him or not depends upon the psychiatrist's decision. He should have The psychiatrist should make sure that the person has mental illness of severity which requires admission, and the patient will be benefited by this treatment, because sometimes people can misuse this law in order to get some kind of relaxation for a crime that they have committed. They want to prove that they have mental illness. For that, they may come to the hospital and approach the doctor for a treatment. So it is the duty or the responsibility of the psychiatrist to make sure whether this is a genuine case or whether it is a fraud, whether the person is some kind of fraud. Okay. So minor shall be admitted only if no other options available. A person under the age of 18, normally we prefer not to admit them if it is not necessary. If necessary, definitely you have to admit the patient. So minor shall be admitted only if there is no other option available, and separately from the adult. You can never admit a minor along with the adult. So there must be separate provisions, separate rooms, or separate wards for the minor as well as the adult. And minor shall not be admitted alone. Along with the minor, there must be a full-time caretaker. And if the minor is a girl, then and if the caretaker is a male, then a female attendant is also necessary. An informed consent of the nominated representative. When you appoint the minor, you should inform and take the consent or the permission of the nominated representative. And a minor who continues more than 30 days shall be informed to the mental health review board. So normally, first of all, you will admit a minor only if it is necessary, and if at all necessary, to be admitted in a separate ward with a caretaker, full-time caretaker. And in the single stretch, you cannot admit a minor for more than 30 days. But after 30 days, if the doctor feels that he still needs to be admitted or hospitalized, then this shall be informed to the mental health review board, and you should get the permission of the mental health review board. This is to prevent all kinds of exploitation. Next, next slide. So independent, I told you that everyone has a right to take an independent admission. So independent admission shall be discharged on request, and if minor upon the request by nominated representative. So a person has come to the hospital and requested for admission, and later he himself feels that he does not require treatment, he wants to go home or he wants discharge, he shall be discharged. You have no right to force him to stay in the hospital. Similarly, in the case of the minor, if the nominated representative is asking for discharge, he shall be discharged. He or she shall be discharged. Leave of absence. This is a new provision of this act. Leave of absence. A person in the mental hospital taking treatment can apply to the psychiatrist for a leave, saying that he wants to go home or for 1 or 2 days and then come back to the hospital. In such cases, if the psychiatrist feels that he is capable of going home alone and coming back alone, in such cases, the psychiatrist can provide him leave of absence. Usually, if people go outside to collect their disability pension, because the disability pension might be coming into their home address, so they want to go to the home and collect the pension and then come back. So in such situation, if the psychiatrist feels that the patient is fit for that, he shall be given leave. And absence without leave or discharge is what we call as abscond. If a person, without informing the medical officer or the psychiatrist or the superintendent, or without asking for a leave, if he just or without the doctor discharging the patient, if he just leave the hospital without the notice of anyone, we call it as abscond. In such cases, we have to inform the police officers, and the police officer's duty is to find this person and admit him back to the hospital. And interstate transfer, sometimes we have a lot of other patients, we might be having a lot of patients from other states. So if you want to transfer a patient from other state to a hospital, to a mental hospital in his or her state, then you should take the permission of the mental health review board. You cannot just write to the superintendent of the other hospital and transfer him. It shall be done only through the mental health review board of his state, or the state where you want to, of the state where your hospital is. So they will write it to the other MHRB. And emergency treatment without considering advance directive. This I've already explained. Even if somebody has written an advance directive and saying that I don't want treatment from this hospital, but if it is a psychiatric emergency and if the patient is brought to that hospital despite the advance directive, if it is absolutely necessary to prevent any kind of harm for the patient and the family members or the society, then despite or irrespective or not considering the advance directive, the doctor can go ahead with the treatment. Next slide. Next, okay. Physical restraint only if absolutely necessary, that too for a short period of time. If a person is violent and coming to the hospital and he is likely to harm others, definitely he has to be physically restrained. But this shall be done only if there is no other possibility. If you can isolate him, then there is no need to physically restrain him. So if isolation is not possible, if he is among a crowd and there is if he is having some sharp weapons with the person and the person needs to be restrained, then you can do it. But it should be done only for a very short period of time. Immediately he shall be given sedation, and then he shall be released from these kind of restraint. And even if when you restrain the person, you cannot do it as in how you want it. You should not you should be very careful in doing that, and this shall not cause any kind of damage of injuries to the patient. and this shall be done only as per the advice of the medical practitioner, and the people in the hospital shall be trained in how to restrain a person physically without causing injuries and damage to the body. A nominated person shall be informed within 24 hours. If a person is brought by the police and he is restrained, then within 24 hours the information shall be uh, this shall be informed to his nominated representative. You have to find out the nominated representative and inform him that the person is admitted and was restrained for some time, and so on. Physical restraint shall not be used as a means of punishment, because in hospitals people may not sometimes obey the orders, or they may not follow the instructions. So in such cases you cannot threaten them, saying that if you don't do this, if you don't take medicine, you will be tied up, or if you are not taking bath, you will be physically restrained. You cannot say that. You cannot consider it as a means of punishment and get things done from the patient. This has to be done only if it is absolutely necessary, only to prevent harm for himself and others. Okay, discharge shall be after discussing with the patient and nominated representative. No patient shall be discharged one fine morning all of a sudden. If the patient is improving, there must be discussion with the patient and his nominated representative about the discharge plan, and then it shall be implemented. In case of homeless, responsibility lies with the police officers in facilitating treatment and rehabilitation of the patient. If a person is homeless after treatment, where will he go? It is the responsibility of the police in such cases to find him a rehabilitation center as per this act, and report to the magistrate ill treatment of the patient in the community. It is the duty of the police officers that if they come across any ill treatment against mentally ill persons in the community or in the family, then they shall immediately report it to the magistrate, the chief judicial magistrate, or the judicial magistrate of first class magistrate. Next slide, please. Now, coming to the civil rights of the mentally ill persons, it is the right, every mentally ill person has the right to vote, because mental illness, even though it is a long term condition, there can be situations that a person intermediary or intermittent situations where the person is normal as well. The patient can be symptomatic for some period of time. If he takes proper treatment, the symptoms will be reduced and he will improve and he will be of sound mind, or he will be sane for some period of time. Then there can be chances that the relapse occur, but then again there is if the patient takes treatment, there is a chance that he becomes normal again. So if a person is of sound mind, then he can definitely cast his or her vote. No one can prevent this person from casting the vote just because he or she has taken treatment in mental hospital or treatment for mental illness. It is only if the court has declared that this person is unfit to cast the vote, he shall not be allowed. Otherwise, the person has, just because he has mental illness or he has taken treatment in mental illness or he's taking medicines for mental illness, that does not disqualify him from casting his or her vote. Then right to make contract. As I said earlier, mental illness is something where there will be both a situation, both a condition of illness as well as recovery, again illness, again recovery, and so on. So in such cases, when the person is of sound mind, during that time, he or she can enter into a contract, can make contract, and such contracts will be considered as valid. So it will be up to the court whether to decide whether this contract was made by the person at the time he was of sound mind or unsound mind. It is to be decided by the court, but the court definitely will take the opinion of the psychiatrist as well. Now, right to execute a will. A person has a right to execute a will if he, at the time of soundness of mind, because there will be intervals of normal intervals of unsoundness. There will be period of normalcy as well. So during that time, he or she can execute the will. And according to the Hindu Marriage Act, marriage at the time of illness, if a person was married at the time of illness by force or compulsion by anyone else, then that marriage will be considered as void, means invalid. Or at the same time, mental illness is a ground for divorce according to the Hindu Marriage Act. And according to the Muslim law, A guardian of a person of unsound mind can consider marriage in the interest of the patient if ready to take all monetary obligation. If the guardian of the patient is ready to take all the monetary obligation, then he can consider marrying the person to someone to someone. And women can, according to the Muslim law, again, women can attain divorce if the husband has been insane for a period of 2 years. And under Christian law, marriage is void if void means invalid if either party was insane at the time of marriage, and in insanity of either partner as a ground for divorce according to the Indian Divorce Act, which is applicable for the Christians. Next slide, please. Criminal liability. This means that according to the IPC, if nothing done by a person is considered as an offense if he was of unsound mind at the time of committing that offense. If a person is committing a crime, and at the time of committing the crime, if he was not aware of the fact that he is doing a crime because of unsoundness of the mind, then he will not be punished according to the law. But at the same time, he will be sent to the mental hospital for treatment, and the court will be asking for his mental health condition. Court will be reviewing his mental health condition. This will take a long term of treatment in the hospital. It does not mean that the court will release him to the society and family. No, the court will not be punishing him legally, but will be sending him to the mental hospital for treatment and asking the psychiatrist or the hospital for a review of his mental condition. Next slide. Now, those are the, so far we have covered the rights of the persons with mental illness as per the Mental Health Care Act of 2017. I told you one more act you have to keep in mind when you talk about the rights of persons, mentally ill persons. That is the rights of the Persons with Disability Act of 2016. This act includes within its purview people with other physical disabilities also. So all the aspects or the provisions of this act are not applicable as such for the mentally ill persons. What is applicable are these 3 points. One, reservation. As per the Rights of the Persons with Disability Act of 2016, 4% of seats, 4% of 4% of seats shall be reserved for the disabled persons in the government sector, but 1% belongs to the of reservation shall be given for the, out of this 1% of reservation is meant for the mentally ill persons. And if a person is mentally ill, he or she shall not be denied of the promotion because on account of his mental illness. So if somebody is denied of the promotion because of mental illness, it is a violation of his or her right. But what happens if the person is promoted and if the person is not ready, is not capable of delivering his duties and responsibility? In such cases, such persons shall be kept in a supernumerary post. Supernumerary post means a post where the person may not have to deliver much of duties and responsibilities, but his pay scale and other service benefits will remain as the same. Okay, so 1% of reservation in the government jobs for mentally ill persons, and if a person after being in a job is having mental illness, his due promotion shall not be denied. If he is not able to deliver the duties in the promoted post, then he shall be maintained in a supernumerary post where his pay scale and service benefits will remain the same, but the duties will definitely be different. And legal guardian. The court shall appoint a guardian for taking legally binding decisions on behalf of the mentally ill person. If a mentally ill person is not capable of taking a legal decision, and if there are some if the person is having a lot of property or bank balances and so on, then, or if for some reason if there is a need for a legal decision to be taken, then the court can appoint a legal guardian in such cases. Then certification. People with disabilities have the right to get a disability certificate from the authorized centers. This certificate is essential for availing the social security benefits and other benefits. So, as per the Rights of the Persons with Disability Act, a mentally ill person is entitled for disability pension or unemployment pension, and the caregiver is also entitled for caregiver's allowance. Disability pension means if a person is having 40, more than 45, minimum of 45 or more than 45% of disability because of his illness, and therefore he is not able to work, then he is eligible for a disability pension from the government, for which he has to obtain a disability certificate from the hospital. Or if a person, because of the mental illness, is not able to work, he is eligible for unemployment pension. And the caregiver, if a person is not able to work because he has a mentally ill person at home and he or she has to take care of this mentally ill person, so he or she is not able to work, in such cases this caregiver is also entitled to have the caregiver allowance. So, but in you might be thinking that one person might get disability pension as well as an employment pension. No, it's not possible. As per the law of our country, one person is entitled to only one pension. So you can either apply for disability pension or apply for the unemployment pension. So these are the monetary social security benefits available for the mentally ill as per the Rights of the Persons with Disability Act 2016 in India. And the right, as per the third act I was talking to you, was about the rights, as was the National Trust Act. So the rights as per the National Trust Act 1999 is the guardianship, the provision for a guardianship. This is applicable for the mental retardation, for the people with mental retardation, autism, cerebral palsy, and so on, of which mental retardation and autism comes under our topic. So the if a mentally retarded person or if an autistic child is having a single parent, or if both parents feel that they are not capable of taking care of the mentally retarded child or a autistic child, they can apply for a guardianship to the committee which is formed under the National Trust Act, and this committee can review the condition, and if found necessary can appoint a legal guardian for this patient, for this person. Yeah, that is the only provision available as per the National Trust Act. Now we have covered almost all the rights of the persons with mental illness as per the existing laws of the country. But when we consider the reality, I must tell you that we have not yet established the Mental Health Review Board. The act came into force in 2017, June 2017, and it is to 2020 now, but we have still not constituted the Mental Health Review Board, and the people are not aware of advanced directive. The people who come to the mental hospitals, they are the common man, the layman. They are not able to understand the law, and they are not able to understand the concept of advanced directive. There has been no effort done so far to make the community aware of these rights and these provisions and so on. So even if the act appears to be ideal, most of its some of its aspects have not been implemented yet. So that is one. And another drawback or the criticism against this Mental Health Care Act of 2017 is that some people say that it is just a copy of the act from the Western world. It is not applicable in the Indian context because the people are not aware of writing an advanced directive, and people are not technically sound, like you cannot um, upload your advanced directive in the site. If you talk like that to the people, everyone in this majority of the people may not understand all these things. So that is one drawback or one criticism raised against this act. So that is a reality. So but we do have a good law, but the reality is a little far from what we actually see in the papers. So, with these words, I have come to the end of the presentation. I once again take the opportunity to thank the organizers and all of you for your patient listening. And I just want to conclude with what Eleanor Roosevelt, who was the chairperson of the draft committee for the International Declaration of Human Rights, said. She said that I cannot reproduce her quote as it is. It is a big quote. I cannot reproduce her sentences as said by her, but I can just tell you the meaning of what she said. She said that any discussion about human rights should come from within you and from within your home and your neighborhood. If it is absent in your mind and in your home, then there is no point in discussing about human rights in any other part of the world. So the change should come from within. So I hope you will all be able to protect, to raise your voice for your own rights and raise your voice to protect the rights of others. Thank you once again, all of you.
Thank you so much, ma'am. That was truly an informative and inspiring session. We have a lot to learn from your words. Thank you so much.
Thank you.
Ma'am, Dr. Shilpa has raised a question
Okay.
that legal aid at any point to get free of cost, whom to approach?
District.
Specifically, if the mentally ill person stayed at home.
The, you should approach the district legal services authority. In every district, there is a district legal services authority. It functions in the same building as the district court. So this district legal services authority has a court, a sub judge, and advocates, and an office staff. So for any legal aid, you can approach the district legal services authority. In short, we call it as DLSA. It is functioning in all districts.
Thank you, ma'am. Thank you.
Thank you, ma'am.
Okay.
Now we are about to end our webinar. I would like to invite Ms. Naisha for the vote of thanks.
Good evening, one and all. Honorable dignitaries, distinguished guests, respected teachers, and dear friends. On behalf of Little Flower Institute of Social Science and Health, its entire fraternity and the organizing committee, I feel immense pleasure to take this opportunity to propose a word of thanks to our manager, Father Bobby Pulolikal CST, who spared the time from his busy schedule to raise the webinar with his extremely talented speech. I would further extend a hearty thanks to DR.SREEPRIYA CK, who is a psychiatric social worker at Government Mental Health Center, Calicut, who gave us a really good session on the topic human rates of patients with mental illness. I would especially thank our beloved director, Father Jose Melete for his support. I take this opportunity to specially express deep regards and gratitude to our respected teachers for always giving energy. Once again, I thank you all for being with us this afternoon. Have a wonderful day. Thank you.
Thank you,
Ma'am,
Naisha.
hello, ma'am, Supriya ma'am,
Okay.
me Shaiju.
Shaiju, parayo.
Just before just before ending, there is one more question from Lakshmi Priya CK. What specific actions are taken by government mental health wing to make the society aware of these acts and its provision because majority is not aware of it?
Yeah, the truth is that even the police department is not very well aware because they are also a party to providing welfare services for the mentally ill. So even the police department, even the people working in the field of mental illness, like the doctors and other mental health professionals, are even now learning this process. There isn't much. We have all learned it by ourselves. We have bought the book Mental Health Care Act book, and we have read it and we have learned it by ourselves, and we have organized a seminar in the hospital and had discussions and so on. So everyone, people who are working in this field are because it is a necessity for them to know about this act, so they are taking their own effort to learn this act. Otherwise, so far, as far as my knowledge is concerned, no effort has been taken by any government to create an awareness about this act, neither among the professionals nor among the laymen. Thank you.
If any other queries, you can raise it now. Yes, we have. It is time to wind up. I think. Yes, we can wind up it.
Okay. Today's webinar is truly an informative in all sense. Thank you all for your participation.
Thank you.
Thank you, ma'am.